All right. Good afternoon. I'm Commissioner Jill Karmy. I'm filling in for Judge Basher. So I know this is typically his docket. He is available, and I'll talk to some folks about that in a minute. He will be available at the end of this docket for cases. I know there's a couple presentations on. If they are not agreed, we can either set it to the end of the docket and he'll step on, or we can set a new date. Let me just start with one case that I know is going to be reset since I am recused on it. Number 4, Monday v. Monday, 22. Mr. Fuel and Mr. Baldwin.
Yes, Your Honor, I'm present. Josh Baldwin for Malia Monday. Mr. Fuel is not likely to be on. We were emailing with Judge Basher. We had planned to set it over a week initially because we got information late that hasn't been able to be reviewed. We understand Judge Basher's out until the 15th, so we're asking to go over to the 15th of October.
Okay, and I did see that he had already agreed to that via email. So thank you all for doing that ahead of time. And we'll set number 4 over to 1 o'clock on October 15th, Tuesday, October 15th.
Thank you, Judge.
Thank you. I see Mr. Anagnosto logged in. I'm just checking in for folks. I know on number 1, which is Smiley v. Smiley, if I have those folks present. This is supposed to be presentation of an order.
Correct.
Is this agreed, or do we need argument time in front of Judge Basher?
I attempted to get a hold of Joanna Smiley, and I haven't heard back. I was hoping she would be here. I've sent her the proposed orders. I don't see her on the list. She was at the hearing. Judge Basher set it for today for presentation, but I understand that if it's contested, it needs to be in front of Judge Basher.
Let me ask to have Joanna Smiley. Okay, and my guess is I just received these orders today, so she probably hasn't had, I haven't seen any response, but I think that would make sense. I think the best thing to do, although I know I'm getting up to speed on this, is to set this over for Judge Basher. However, he won't be back on this docket until October 15th.
And some of the judges used to have a Friday presentation docket. Does he have a Friday presentation?
He has, I believe he has presentation. Do you know? Presentation is at capacity. Oh, this Friday it is at capacity. What'd you say? He is not back until the 15th on this docket, but some of that's scheduling and some of that's him just being out. I could, Mr. Anagnosto, if you want to wait until end of docket, Basher will log on and he could deal with scheduling this for himself if you want to just hold tight or log back in.
I can just hang out here. Sure.
Okay.
I'll wait.
Okay, I'll let him know that we'll take care of that one.
Thank you, Your Honor.
Thank you. I also have presentation of an order on number 5, Jacob Dooley v. Kiana Morris. Do I have those parties present?
Amy Powers here for Miss Morris. Miss Gilmore and I have both signed off on the order. We sent one over this morning with interlineations that we've both initialed and dated. If those can just be left for Judge Basher to sign, that would be fantastic.
Okay, and I think this is the most recent one. Yep, the cover sheet is September 24th. And I do have the interlineations on mostly the child support order. Is that?
That's correct. You've got the right set of them.
Okay, perfect. So what I can do, and do I have the other party present here?
Miss Gilmore is not able to attend today, but I told her I'd let the court know.
Okay, great. What I'm going to do is just paperclip these. And before I forget, I'm going to put a sticky note indicating that these are approved for his signature. And I will put those in front of him. Is there anything else we need to do on this matter?
No.
Okay.
And then while I'm here, could we call number 6, Christopher Diaz and Casey Hawkins? This just needs to be set over to October 15th. Miss Ernest was not planning to appear. Mr. Lawrence is the GAL. We're all in agreement to set it over to October 15th.
Okay, and I did see this was just on for review hearing. There was some contemplation today might be struck anyway. So
Yes.
do we have Christopher Diaz or Casey C. Hawkins? I do see Mr. Lawrence there. Good afternoon.
Good afternoon.
Okay, any issue, Mr. Lawrence, with setting this over to October 15th?
No, Your Honor.
Okay, we'll get number 6 set over to October 15th at 1
Do I
p.m.
have
Thank you.
The petitioner online. Is it Pinot or Pinot? Pinot, okay.
It's, you know,
Just like the wine, okay. So Mr. Pinot, I'll ask again, I have a lot of names on Zoom here, so I'm just looking through them. Do I have Joshua Pinot?
It does not appear so, Your Honor.
Yeah, I'm not seeing them, and I see you, Ms. Lawrence, thank you for being here. Is the state of Washington active on this one?
Yes, Your Honor, but it's likely that after this order, the state will withdraw. I have not seen it, but we don't have any stake in the contents of this particular order.
And so I have it on for presentation. Does this need to be argued at the end of docket in front of Judge Basher? Or, I mean, I don't have Mr. Pinot here.
no, you can just go ahead and sign that. He has been in communication with our office, indicated to my staff that he agrees with the order, will not be contesting that. I understand that's probably why he's not present.
Got
He
it.
usually appears in person. So I think we're agreed on that, although we do not have a signature from him. He was going to try to forward that to us, but it looks like he hasn't made it over unless he's been here in the last half hour or so. So my understanding is agreed.
Okay. I know there was a gentleman here with a kiddo. Is he associated with a case? I wonder if.
No, I doubt it.
Oh, he's with you. Okay. Yeah, he is with someone else here. Okay. There was a gentleman here who stepped out. Okay. So what I have in front of me, is the proposed parenting plan resulting from that hearing. Is that all that you are asking the court to sign today?
Yeah, that's it. The GAL order has already been entered. Miss Lawrence has been investigating that. That was the product of the parenting plan from last week, and child support was not at issue. So I think with signature of the parenting plan, that should get us where we need to go today.
Okay, I have signed that. Ms. Russell, anything else you're requesting from the court today?
I would just like to confirm that that is a permanent parenting plan, not a temporary at this point.
I'm indicating temporary.
It's temporary.
Okay, thank you.
Yep. Okay, I will hand that up to the clerk and go ahead and consider that matter concluded. Let me just check in with the rest of the parties then. Are there any other cases where because of history or other preference, it needs to be heard in front of Judge Basher, and then we can talk about scheduling?
There's an add-on, Judge. It's number 8 on my docket. I think the clerk's office added it late yesterday. Sane, insane. Is that on your docket?
It's not on my printed docket, but I do have it in my judicial odyssey here. Yes.
So the orders we're on for a compliance hearing with the GAL. The orders, I understand, just got signed and entered yesterday. Mr. Lawrence was appointed as the GAL in that case. And there's really nothing to report. He unless he shocks me, has not had time to do anything on this yet. So I just ask that be set over several weeks or alternatively stricken.
Okay, let me just check in. Do I have any other parties on the Oli Sane and Raisel Sane?
Yes, Your Honor. Yes, Your Honor. I'm here. My name is Raisel Singh.
Okay, so it sounds like the request is either to set a new review date or strike this. I'll just note, I do have the GAL order appointing Mr. Lawrence. It had previously set a 30-day review today to review for compliance and payment of fees. Mr. Lawrence, any input from you? I don't expect there to be too much.
I just got the order appointing me this morning.
Okay. Do the parties want a 30-day set out from today? I'll just note the only other date set is 12/31 for final review.
I don't necessarily think we need it. I know the court likes to track these things, so I guess I'm neutral either way. If we want to set it out 4 or 5 weeks, into early November, I'd be okay with that. But again, I'll rely on the preference of Mr. Sane and the input of Mr. Lawrence in the court on that.
My thought is just to review to make sure we're not having a hiccup with payment of fees and that sort of thing, that we do go ahead and set it for October 29th at 1 for a quick review. Would that work for the parties?
That's fine.
October 29th. So, Your Honor, so by October 29th, I have to provide the fee for Mr. Keith Lawrence, right?
Well, preferably before then, so he can get
Before then?
working on it. But at that point, we would review to make sure those things are taking place.
What would be the amount, Your Honor? And how am I going to pay it? What format, like check or credit card or?
On your bird, it's sitting right there.
Well, yeah, if your case isn't being called, just go ahead and mute yourself. I'm showing that you're paying 86% of the GL fees within 2 weeks. That order was signed yesterday. So within 2 weeks of that, you can reach out to Mr. Lawrence regarding that.
Okay.
Okay, it looks like 14% will be by county pay.
6%. Okay. And then Your Honor, I don't have any representation representing myself because of my financial distress. And so the October 29th will be the court hearing date again, after I pay the amount to Mr. Keith Lawrence within 2 weeks from now on, right?
Correct. It'd be October 29th at 1 o'clock. You'd log back in just like you did today. Family law.
Okay. And on that day, what would be the reason for logging in? Like, should I bring something, or what should I do?
Our hope is that both parties have been compliant with talking to Mr. Lawrence and any requests he has to work on his recommendations.
Right. And also, Your Honor, my other thing is that the court order that was signed yesterday, that's a temporary court order, right? Because I would be like to contest pretty much all of it, and I will have all the documents for Mr. Keith Lawrence to review a lot of the stuff. Yeah.
The temporary order of child support,
right.
Is that what you mean?
Okay.
No, I'm asking what you mean. The GAL order is not temporary. So I'm asking what order
no, I know the GAL order is not temporary. Your Honor, I was referring to the parenting plan and the all the other payment, the child alimony. Those are all temporary, correct?
It is a temporary family, correct? Those are
okay.
Okay.
And so
hold on, sir.
Sure.
I want to make sure before we use this date too much that Mr. Lawrence is available October 29th. Oh, you're muted. Sorry.
Sorry about that. I'm available that date, and to aid Mr. Sane in what the payment obligation for him would be, at 86% of $3,300, it comes to $2,838.
Okay.
Thank you. I appreciate that. Okay. And then, so, Mr. Sane, anything else you need?
Your Honor, for Mr. Keith and for me to compile all these things that I would like to contest, and I have to go to court and ask CPS for various records. And is there any way you can extend the date from October 29th to later on? Because 30 days is not pretty good enough to bring all the paperwork together. But God willing, I would provide the amount that we owe him in 2 weeks. I could do that because I'm borrowing money from my parents, so I could do that. That shouldn't be a problem. Yeah.
I'm going to keep October 29th. That is not the date by which the report and recommendations are going to be completed. We have that date set for December 31st, I believe. So we'll keep the October 29th date. That'll just be a check-in. I don't expect everything to be completed by that date.
Okay.
Okay.
And the December 31st date would be the final date for court to judge to confirming, right, for the order.
And that can change depending on how Mr. Lawrence sees this investigation and report going. But for now, we do have that set as the final report review. Yes.
Yes. Okay. Thank you, Your Honor.
Yes. Anything else on this case?
No.
Okay. All right. Thank you all.
Thank you, Your Honor.
Mr. Keith.
Amy Powers
And
here for
then-
Teresa Purcell.
Steve Madsen here for James Young.
Okay,
And for the court's awareness, Teresa Purcell is present in my office.
okay. And then, Mr. Young, is he, I know sometimes he zooms in for dockets. I don't know if he's here today or not.
Yes, I see his name up there.
Let's see, I've still got 2 pages I'm scrolling through. Give me just a second. Mr. Young, are you able to hear the court? I'm gonna send you a request to start your video, but really I'm hoping you connect to audio. Okay, well, let me start with this while he might be figuring this out. I know, Mr. Madsen, you were appointed on September 6th.
Yeah.
How are the parties asking to proceed today? I know originally we've kind of pushed over the temporary order hearing to get counsel, but I know we haven't given you a lot of time here. So what would the parties like me to consider or do today?
Your Honor, I can only tell you my experience in the case so far. I have spoken with Mr. Young twice on the phone. I don't think there are significant, well, they're significant to him, but I don't think there are any significant impediments to the completion of this case. I did just get some of the information that we had requested from Ms. Powers yesterday afternoon or evening, and was only able to discuss those matters with my client this morning. As far as I'm aware, the only two well, I shouldn't say the only two, but the two primary matters have to do with we'd like to request an accounting of the funds that Ms. Powers and I discussed. She's aware of what I'm referring to, and we need to resolve the pay situation with the Social Security benefits. And I'm not familiar enough with that matter to know if it can be resolved through these proceedings, but I think there could be part of the both the temporary and permanent order that reflected that would allow Social Security to make direct payments to Mr. Young. So that's going to be the request. I think that if we had just a little more time, we could probably hammer out those couple details, but it's up to Ms. Powers.
I was hoping that the court would go forward today at least with a temporary restraining order. We have a protection order case that's been trailing this case, and so if we can get a temporary restraining order, our plan is to drop the protection order, and it would be great if we could accomplish at least that today. The only other request my client is making on a temporary basis is to be able to continue residing in the home, using her car, and having the pets in her custody.
I haven't spoken with my client about that, but I personally don't have any objection to that. I mean, the protection orders.
Hello, I'm here.
Oh, there's Mr. Young.
Sure, Mr. Young, thank you for joining us. Okay, go ahead, Mr. Madsen.
I just to reiterate for my client's benefit, I don't have any objection to the items in the temporary order because the protection order is in place, and I don't think there's anything being asked for that the court probably wouldn't be inclined to grant. Nothing in the temporary order affects where we're at in terms of asset distribution or the Social Security issue that we spoke about. So unless but I haven't spoken with Mr. Young, so I'll defer to him if there's anything specific in the temporary order that he objects to.
And I think, Mr. Young, thank you for joining us. We have your court-appointed attorney here, Mr. Madsen. I do want to, at least today, because I know it's been going on some time, address the temporary restraining order. Mr. Young, are you objecting to the court putting in the temporary family law restraining order?
Well, there's already in place another restraining order in a different case.
Yeah, and that one's likely going to be dropped when this one's entered.
Okay, I was interested in figuring out more of what happened with under the power of attorney that my wife has had. And for example, there were 3 different sales of stocks at a total of $45,000, which is a fair amount of money.
Yeah.
And just said it was used to pay bills, but there was no specific accounting of how that money was used.
And none of that would be addressed in the temporary order that I'm looking at. It would just continue the current restraint provisions that are already in place. And it would allow her to continue use of the 2016 Toyota Prius, and the pets would remain in her care. Are you in agreement with those?
Yes, that's okay.
And again, this would just be on a temporary basis. We would be able to readdress under full orders. Mr. Madsen, it sounds like your client is okay with those.
Yeah.
And I'll, just for full disclosure here, Mr. Young and Ms. Powers know this. I have been handling the civil protection order case as well because Judge Basher is excused and he's the only other judicial officer that does those as well. And my understanding has been on the CPO docket that likely the CPO will go away at the next hearing if this family law restraining order is put into place. And frankly, I know you're just on this. I'd probably give you more time to go through this with him, but I think the family law restraining order being entered and the formal CPO dropped is to his benefit.
I agree, Your Honor.
Yeah, so I am inclined to go ahead and sign unless there's some objection or argument that needs to be made.
Not at this time, Your Honor.
So what's the difference between the civil protection order and the family law restraining order?
The family law restraining order just still restrains you from contact. It just doesn't look bad on your record like a civil protection order. And I'm trying to say that a better way, but it means sometimes civil protection orders, because they show up on background checks, can preclude finding rentals, finding employment, things like that. Whereas a family law restraining order is active and you must abide by it, but it doesn't sometimes have the same negative outward societal consequences. Does that help? Okay, so I am going to go ahead and sign with those temporary provisions. Ms. Powers, I know that you have submitted those in the past. They did not make their way forward to this docket. So would you be willing to resubmit the temporary restraining order with the use of property for family home, Toyota Prius, and pets?
Absolutely. I think Mr. Madsen and I should be able to both sign off on the order, and then I'll just send it over to Your Honor. Can I just clarify one piece on the temporary restraining order? We, in the protection order case, Mr. Young is restrained from the barn along with the home. I believe that we missed the barn in our request for temporary restraining order, but we would ask that the barn be included where my client's horse resides.
I do think, especially given my knowledge of where the parties separately are residing right now, I don't see any issue with that. And frankly, the proposed language, and I'm happy for you all to modify, but right now it says do not go onto the grounds of or enter my home. That's probably broad enough to include the barn. But
the barn is on a separate property.
Oh, okay. Mr. Madsen, then I guess that is a little bit of a change from the proposed. Do you or your client have issue with the barn language?
I'm going to defer to Mr. Young on that.
It's been in the CPO, so I don't think it's a change in circumstances.
Yeah, I would, well, it's a tough spot for me to say, but personally, I would not see that it's a distinction without a difference as far as I'm concerned. But
Mr. Young, do you have any issue with the barn being included in the family law restraining order?
No.
Okay. Thank you, Ms. Powers, for that clarification. Yeah, if you two circulate that order, and then you can email it directly to me, I can print. I'll be here most of this afternoon and all day tomorrow. So if you shoot that over with digital signatures, I can print, sign, and file.
Fantastic. Thank you, Your Honor.
Okay.
I'll actually be next door to Ms. Powers in the morning for a while tomorrow. So if she needs me to just stop by and sign it, I can do that as well.
Okay, great.
Thank you.
Okay, well, Mr. Young and Ms. Purcell, that concludes your matter for today. Do you have a date forward, or do we need to set any dates forward at this time?
I think that Mr. Madsen and I can work together. I'm hopeful that we'll be able to get this settled fairly soon.
Okay. All right. Thank you all. You're free to log out.
Thank you, Your Honor.
No date set for another hearing at this point?
Correct. You probably will have another hearing, but your attorney will set that, or Ms. Powers will set that, and you'll be notified, but nothing for right now.
Okay.
Okay. Thank you.
Thank you, Your Honor.
Do I have Marcus Ruby present?
I tried to reach out to him a couple times and have not heard back.
Okay. Let me just get into that digital file here. Real service. I have service of the child support order.
Well, this hearing was continued when Judge Evans had to recuse himself.
Okay.
I
Well, I'm
believe
just
Mr.
looking
Ruby,
at motion for temporary orders with proofs of service in August. Has something occurred since that time?
I do not believe so.
Oh, no, on September 4th, Judge Evans had to recuse for conflict. So at that time, thank you, Ms. Turnbull. I wasn't seeing that note. You all were present, and so this doesn't make a whole lot of sense. It was set to September 17th. Yeah, I'm just going through the history here because we have a recusal. Oh my goodness, okay.
The 1 p.m. docket, but I don't know what happened.
So what happened? What happened on the 7th? So from your September 4th hearing,
Yep.
it was set to the 17th. Did you all appear on the 17th?
Ms. Turnbull appeared. Marcus was not present at that hearing as well.
And then, because I don't even have notes from the 17th with the clerk.
Judge Hahn had to recuse herself as well because of a conflict of interest.
Yeah, normally we would have notes showing that. So did the hearing on the 17th take place? Because the clerk and I don't have those notes.
I appeared, Ms. Turnbull appeared via Zoom, and she said that it was set over to today because of a conflict of interest.
Okay. And I'm not, are you seeing anything with that in there?
We had an email
Okay.
that asked us to set it over to 1 p.m. on the 17th, but I was gone that day, so I'm not sure what exactly.
Okay. And so Ms. Turnbull, what I'm trying to establish is that Marcus had actual notice that today at 1 o'clock was the date for this continued hearing, because our records aren't showing that.
It might not be clear, to be honest.
Okay.
It was clear to me. I think it was clear to Ms. Ronzo. I'm not entirely sure it was clear to him.
Yeah.
Judge Hahn stated that there was phone calls made to let both me and Marcus know that the court date had got set over, but nobody could reach me by phone. Nothing was clarified whether he was reached or not.
And I've been having trouble reaching him, so I don't know if the court would be able to reach him if they had tried.
Yeah. What I'm inclined to do, I know, and I'll just, that we don't have any minute notes about the date and time. Oh, go ahead.
There's just a rescheduling here from the 17th at 9 to today, but we don't have any way of verifying that he actually was
notified. What I'd like to do is, well, someone's back there shaking their head. That's not what we're going to do in the courtroom, ma'am.
Sorry.
So, I can't, I mean, you've had a lot of recusals, and that is no fault of your own. I just can't move forward with the hearing if I'm not satisfied that all parties were notified. I'm not satisfied that Mr. Ruby was notified that today was the date and time. That doesn't mean he wasn't. I don't have proof of it, and that's not a fault of you or Ms. Turnbull or anyone. It probably falls back on the court. There's nothing in the file that shows he knew about this. So what I'm going to do is give you a new date that works for you. I'm going to, again, folks, stop.
Okay.
No, I'm not talking about you. I'm talking about folks who are here observing. Stop shaking your heads, because you don't have to be here and you can leave the courtroom. Okay. There are certain criteria I have to meet to enter an order when someone is not present. Those criteria aren't met, and I'm not blaming anyone but the court. We haven't documented that he was notified. I am going to document it in an order and give you a new court date. I can set you on. Is our October 1st closed?
No.
It's not. Oh, that must be Judge Hahn's.
No, we were good.
Oh.
No one going, but Judge Hahn was very full, so, but there's a recusal anyway, so it has to be subject to the classroom next week.
Okay, so I could do October 1, which is next week, or October 8 at 1 o'clock. Do you have a preference?
The sooner the better.
Okay, October 1st. And then Ms. Turnbull, does that work for you?
Sorry, I muted myself. Yes, it does.
Okay. And then I'm going to create that order We will mail it out, but does anyone have a good email for Mr. Ruby? I would prefer to have the judicial assistant email him the order.
I have an email for his wife that I could put into the chat momentarily.
Okay. And I'll check with the clerk too. Do we have an email on file for him?
Yeah, I have Brooke just seen one too.
It's different.
Oh, yeah. If you would put in the chat what that is, we'll email the order to him.
Okay, great.
Okay.
Very good.
Okay, we'll have you back next week, Tuesday, after he's notified. And even if he's not here next week, we will move forward.
Okay, so,
Okay.
The documents that were handed to you, can those stay with the case or?
They will stay with the case. Let me just make sure I've got everything that you submitted so that doesn't become a question too. I
can't file that without a cover sheet.
Oh,
these we'll keep until next week.
We will keep these. Yes. Oh, were these not filed yet? No. Okay. So what I'm gonna do, it looks like you handed up some documents today that haven't been filed yet.
So the court, the dismissal for CPS, I filed on Friday, so by next week, hopefully you guys have it.
Okay.
And then I will go file the UA.
And actually, just give me 1 second. I think,
This we don't need to actually have it.
we have access to that.
Okay.
So
I just want to
you
make
could
sure
just
the court had a
reference
copy of
that. I have filed under seal a 920 UA. Is this one different?
This is new.
This is just from today.
So go ahead and file that one.
I would say so being in drug court and whatnot, as soon as I get them, I get a copy of it and I bring it over.
Perfect. So if you do that now, we'll have it by next Tuesday online. And then the orders that you prepared will go back to the clerk and carry over to next week.
Okay.
Okay.
All right.
Okay. Yep. Hang in there.
Judge, I'm present. Can you, oh, sorry, Ms. Jocelyn. It seems my video is malpracticing, but can you hear me okay? Oh, there,
we see you.
Maybe, okay.
Sorry, Ms. Bliss, we started talking at the same time.
There you are. Let me just get into this digital file, and I don't believe I have proposed orders. So tell me if you all sent them and I'm just missing them.
There are not proposed orders.
Okay. I do have a submission of documents. The most recent thing I received from the September 8th filing from you, Ms. Jocelyn.
Yes, that was just the exhibits had inadvertently been left off of her reply deck.
And so are both parties wanting to move forward on the hearing for temporary orders today, or what do you all want to do?
We're ready.
Prepared to move forward today, Judge.
And let me just make sure, and again, you all know I am pinch hitting here. When I look in the in our digital file, the proposed orders I have from Ms. Jocelyn are from September 3rd. Is that still the parenting plan and temporary orders that you're advocating for?
Yes, I apologize. We did submit a proposed parenting plan on the 3rd. Yes, that and then a couple other things on our motion.
Okay.
And I think we both realize this is sort of a complex case, and I think this is Your Honor's first time. I think it's mostly been in front of Judge Bassett.
Okay. Yeah, I was looking back. I saw there were, I guess, help me out a little bit here to get caught up to speed before you jump into argument. There's been some temporary orders before.
Yes.
All right. So are these replacement temporary? Like we're not, I guess, help me out a little bit where we are procedurally.
Yeah, procedurally, we have temporary orders. We're not asking to change the time. We're asking to have set days. The prior orders don't have set days due to opposing party schedule. So from the parenting plan, all we're asking to change is 191's sole decision making and to have set days, not change his time. And then our family wizard and therapy are new issues that weren't included in temporary orders prior.
Ms. Bliss, just your preliminary position on the procedural placement by ourselves.
Yes, Judge, that's my understanding of what the request is before the court. It's essentially requesting clarification and or modification to the current temporary parenting plan that's already been in effect.
Okay. Okay, so Ms. Jocelyn, then, as the party, go ahead with highlighting anything you want the court to take specific note of.
Yes, I know Your Honor is very diligent when she does cases, but since this is your first, I wanted to give a little bit more in depth. And if you feel like it's too much, kindly cut me off at any time. So we filed today regarding what you had just stated, along with attorney's fees of $15 for having to file the motion, and then $1,000 in sanctions in regards to the response. The first issue, I don't know if I need to get into it. If I can clarify with Ms. Bliss, it appears her client is now in agreement to changing therapy centers. If that's true, I don't need to go into argument on that. And we can just get an order that it's ASAP start.
And yes, Judge, if I may just jump in here, as indicated in my client's responsive declaration, now that he's been provided the documentation that he's been requesting, he's in agreement with changing to that Cornerstone Center in Chehalis.
Okay, so we'll, that was number 1 requested on number 8 in the motion. So we can take that off the table for discussion or dispute. Are you, Ms. Bliss, just to clarify, is your client objecting to the non-emergency communication family wizard?
Yes.
Okay. All right, go ahead, Ms. Jocelyn.
Thank you, Your Honor. The only thing I want to say about the therapy center is just our prior attempts to communicate, which supports our request for fees. My client reached out to opposing party on 10/13. That convo ended in harassment. She reached out to him on 10/25, indicating she was able to get an evaluation so the child could attend Cornerstone. He didn't cooperate. On 10/30, the evaluation was set. Opposing party refused to bring him to that evaluation. We had also sent correspondence to Ms. Bliss about changing therapy centers. We sent an email on January 16th. We got no response. We sent a follow-up on February 9th. We got no response. So that's going to be part of the reason we're asking for fees. In regards to the parenting plan, the changes in regards to set days, I think, is the first and foremost. These parties have a lot of conflict. I think that's something Ms. Bliss and I can agree on, is this case has just been wrought with conflict between the parents. We did have a prior hearing on H23 in front of Judge Bassett, and we were discussing the issue of days and notifications. And at that hearing, which we never put into orders, she basically said he needs to provide his schedule as far in advance as he gets it, the Friday before. So father gets a year-long schedule, and then if it changes, he gets another temporary schedule. So the issue with my client is that he's not getting it timely. Basically, he's controlling the schedule based on when he wants the child or not. So he does receive the year schedule. My client has that. He has the ability to notify her at least 2 weeks in advance of any changes. As was evidenced by the email sent to Ms. Halley, August's teacher. Additionally, she was with opposing party for quite some time. He's been at the same job. This temporary crew schedule, if it changes, he gets it 5 to 14 days in advance. And so what he's doing now is he's giving her less than 72 hours notice of the date he's going to use when he has a year-long schedule and then a temp schedule, if it all changes 5 to 14 days in advance. And I think that's one of the biggest issues here. He's not following the court direction from last year that he needs to give that temporary schedule as soon as possible. And this is where the problems are arising with visitation. It just makes no sense why he wants to wait. You know, if he wants to co-parent, if he wants to be an active part of the child's life, you would think he would say, here's my schedule. Right now, it's my client who has the sole responsibility of ensuring that August has childcare on her days and on the days that he should have them according to his schedule. Her husband works demanding nights as a shift, as a ER nurse. She juggles multiple jobs or job and also has another child. He states the reason I can't have set days is I can't do childcare. I can't have childcare. I don't have the help. You don't need help. You don't need family and friends. That works where you have daycare, specialized providers for. That is just his job of being a parent. He has to find times for somebody to watch his child when he cannot watch him on his days. He doesn't have to have his family or friends. He can simply find a provider, then he bills my client for it. She has to pay a proportional share. She has no objection to that. He can also ask my client, hey, I can't do this day. Can you do this? I think the frustration comes with my client doesn't get to pick or choose. Parent doesn't get to pick and choose when he wants to be a parent. All he's doing right now is having a child when it's convenient for him, when it's the days he wants, when he doesn't have to provide childcare, he doesn't want to figure out childcare. He's getting all the fun, but he's not doing any of the work of having a child, especially with this child and all of the diagnoses being nonverbal autistic. A schedule ensures consistency for the child. Even the doctor's note from September 12th said minimizing transitions between the home would help him respond to therapy. That's why set days is going to not have the conflict between these parties. We have the set days. If it's on a day that he can't do, he needs to find childcare. My client can't work the jobs that she wants to work or the hours because she has to wait on him to give a schedule less than 72 hours in advance, and he doesn't want to bother to find childcare. So she can't better herself for her family because she has no idea of when she can plan to work and tell her employer when she can work and also going to school. My client just simply wants a schedule based on his year-long schedule. It's the same days. It's the proposal in our parenting plan. If something changes, he can certainly ask her, but if not, then he needs to find childcare. Regarding sole decision-making, Jeremy is demanding that my client make all these appointments on Jeremy's days off. And then when she makes them based on her long schedule, Jeremy then said, I'm either not available or demands my client change the appointment. Some appointments that have been scheduled for months. We're not talking about an urgent care visit that you can walk into. We're talking about specialists and evaluations for a child who has a long list of diagnoses that you can't just reschedule. He won't bring their son to appointments on his day off just simply because he doesn't agree with it. Example, the evaluation on the 30th of October. He doesn't speak with my client and engage with her about why he disagrees. So she'll say something on a legal decision-making thing. He'll just say no. He doesn't say, hey, I want more information or what about this? It's just a flat out no. He's only participated in 28 out of 88 appointments she has had for him in the last 2 years. She explained to him 3 different times. Counsel he refused, and he's only agreed until after we sent a motion. He's constantly saying, I'm not informed, when all of our family wizards, the messages, the declarations from her husband, Dale Holt, all says he was informed. He's not following doctor's orders. He's ignored the extensive list of diagnoses and his disabilities. He ignores medical bills are due. He says he's current on support. He's not. He's behind by $538.72. And if you look at the pamphlet we had attached from DSHS.gov, it's basically showing that what he's doing is serious enough to warrant a formal report, and his failure to acknowledge crucial medical notes and recommendations from his care team is directly impeding their son's cognitive development and growth. And so in addition to that mention, he's basically failed until this motion to recognize his son needs a new therapy center. He didn't make any effort to find a new therapy center. He didn't participate in discussions about a therapy center, and he refused to allow their son to attend the evaluation. If for some reason the court is not inclined to set days or sole decision-making, we would then ask that a GAL is appointed to weigh in on this and any recommendations the court has, and we continue this hearing. Regarding our family wizard, it's important to note that my client has a domestic violence protection order against opposing party. This is against her. It is not against the son in this matter. It's against her eldest son, Bruce Hegdahl. She got this protection order based on the abuse, the physical, the sexual, the emotional, and the abuse that Bruce suffered. My client should not be forced to communicate via a text message or through her husband with her abusers. They used our family wizard before, and then he just stopped. Again, he wants to control it. They used it for an entire year. Her husband's been the intermediary since October of last year. He doesn't want to do it. When we were going through this DVPO, opposing counsel consistently made the point of, we are doing this so we can force him to use our family wizard. When we called their bluff on it and said, my client will pay if we can use it, which opposing counsel's position has always been, you pay, we'll use it. When we called their bluff, I sent them an email, I sent them a stipulation. My client had a check ready to go that weekend for our family wizard. They never responded to our March 28, 2024 email. On November 9th is when she said, if you want to use it, she can pay for both parties. We went back and forth for a while, and then I finally ended up sending the email in March. Regarding attorney's fees, he should be required to pay $1,500 in fees for us having to file this motion, especially regarding the therapy and our family wizards. We sent 2 emails regarding therapy. Opposing counsel failed to even respond, not even a no, just a flat I'm not saying she has to agree, but she could simply say, my client doesn't agree. It was just a flat out no response. We did exactly what they wanted with the Our Family Wizard. We said she'll pay. Again, flat out ignored the email. Jeremy and his counsel basically have continued to ignore our efforts to move the case forward. And in the declaration state, we are not moving the case forward. We've waited 8 months on some of these issues regarding the therapy. And it appears that, as we stated, he now agrees. So my client should not have had to file the motion. Regarding, I guess I'll go forward with the sanctions issue after opposing counsel does her response.
Okay.
And Judge, I would ask that she go forward with the sanctions because obviously I'm going to need to respond to that issue.
Well, it was raised in our reply based on what they said. So they don't get a reply to our reply.
Yeah,
you can't make a request for sanctions and not allow any sort of response.
Yeah, hold on. So what I'm going to do first, let me hear just on the substantive request for changes. Then we'll move over to Ms. Jocelyn's request for sanctions and Ms. Bliss's response.
Thank you, Judge. As the court is aware, I do represent Jeremy Cook in this matter. In looking at the requests made by Ms. Hegdahl, obviously the easiest one is the one that was agreed, and that is the therapy. As contained in my client's responsive declaration, there's a lot of issues with trust here. There's a lot of issues with trust, a lot of issues with communication. He indicates in his responsive declaration, all he asked for was more information. That's all he wanted. And so to claim now that he forced this motion to go forward because he didn't respond, that he was not compliant with any sort of communications, to say that he never inquired as to why there was a need for a change, provide me some sort of doctor's notes that say that he needs to change, things of that nature is disingenuous and I think fail to be proven by petitioner's claims. What my client has repeatedly said is he is trying to co-parent with Ms. Hegdahl, or excuse me, Ms. Holt. No offense is intended there. I do understand that she did just change her name. So Ms. Holt, he has repeatedly tried to work this issue out. He provides in his responsive declaration, he had repeated conversations with Dale, who has been the intermediary, who has been the party that both parties have consistently agreed is the appropriate middleman. He provides that he had several communications with Dale as to where are we at with therapy? He needs the occupational therapy. What are we doing with that? And repeatedly it was, I'll talk to Ms. Holt, I'll talk to Ms. Holt, and then there was nothing. It wasn't until this motion was filed that we were provided documentation as to the actual need for the change of therapy.
And Your Honor, we're going to object. We've proven that they've received documentation in January. So this is flat out.
Go ahead, Ms. Bliss.
Thank you, Judge. So the fact of the matter is Ms. Holt has consistently refused to co-parent with my client, which has then caused trust issues, which I think is apparent. My client is asking the court to not make any changes to the parenting plan, and I'll get into each individual prong within that. I do think counsel's suggestion that a guardian ad litem be appointed is probably appropriate at this point. I know the parties have consistently avoided the need for a guardian ad litem in hopes that we could eventually get there for purposes of co-parenting, but it's clear that that's not currently the case. When we look at the requests made by Ms. Hegdahl, or Ms. Holt, excuse me, I do want the court to consider the history of the case. And I did discuss this, my client discussed this in his responsive declaration. We have a significant history of attempted alienation in this matter. Ms. Holt, from the very beginning, has attempted to control the entire situation as to him not being allowed to have overnight visits. To the initial proposal is very similar to the current proposal, and it is going to have days in which my client has no time with the child during his time with the child. The court took a lot of consideration last year, Judge Fassett in particular, into this schedule and agreed that it was in his best interest, at least at this point, given my client's rotating work schedule, to ensure that this child actually had time with both parents. As the court is aware, we do work in a town where there's a lot of shift workers. There's a lot of day shifts, night shifts, rotating schedules. You can't have a set schedule when you have those type of work schedules. In the perfect world, yes, we would have two parents on similar schedules, and this child could spend quality time with both parents. My client's not attempting to negate responsibility of being a parent. He's simply stating if you schedule set days and he is working day shifts, night shifts, the like, this child will spend the entire time with a babysitter or a daycare, which isn't financially beneficial for either party, nor is it beneficial to August to not be with a parent or not be with the village, so to speak. And my client goes into that substantially in his declaration of Ms. Holt has a large crew of folks that help care for this child, and my client appreciates that. He knows that that's in August's best interest to maintain that village. There's extended family, there's previous partners, family, and the like. My client, again, is not attempting to negate responsibility or to shift responsibility. He's simply asking the court to, A, continue the status quo, which arguably is always in the child's best interest, especially when we have a child on the spectrum, but alternatively, allow August to remain with a parent or fictive kin, at least in this regard, during the time that he can't be with a parent. So that's as it relates to the schedule change. My client provides to the court and has consistently provided to the court and to counsel and Ms. Holt. He provides notice as soon as he can. Counsel, even in her own argument, said he knows between 5 and 14 days prior to the time. He provides in his declaration, he provides at least 5 days notice every single time he can. Again, there are schedule changes. This is what happens when we have flexible shift work. Previously, it was an argument of he's not providing the year-long schedule. We provide the year-long schedule. Then it becomes an argument of he's letting me know last minute. So we have the 5 days or as soon as reasonably possible. My client is consistently complying with not only the court's order, but the request of Ms. Holt. However, the goal line continues to change as soon as he starts complying. This is, again, as it relates to the alienation claims and the control factor in which Ms. Holt is possessing in this case. I went into a lot of the different alienation issues. I think that that's probably more in line for a guardian ad litem to determine, not Your Honor, at least not on this short-term basis. Similarly, as it relates to the request for 191 factors. Again, I don't think the court should or could, based on the filings, enter those findings without more information. It was not, although it was pled in a temporary parenting plan or the proposed parenting plan, there was limited information provided to substantiate the allegations. What has been provided has been conjecture, has been Ms. Holt's version of events. Obviously, my client contests those. My client does have a very bonded and loving relationship with this child. That's not contested by Ms. Holt. To make these significant 191 factors on the say of Ms. Holt without a neutral third party investigating, I think would be contrary to this child's best interest. Looking next to our family wizard, again, this issue has been hotly contested for, I'd probably say, almost years at this point. My client indicated in his declaration, the parties initially utilized our family wizard because Ms. Holt mandated that they do. That she wouldn't allow visitation if he didn't use our family wizard. This was prior to the initiation of this action. Once the action was brought forward, Judge Fassett, I believe Your Honor, heard the CPO in this action. Neither of you had ordered that our family wizard be used. My client simply chose not to continue using it. Again, as he indicated in his declaration, the parties solely use our family wizard for texting. Why are we spending hundreds of dollars a year on a texting app? The parties have agreed since the CPO was entered to utilize Dale. My understanding is that has been working wonderfully for the parties' communication. They aren't having communication between each other anymore. They're using Dale. And I think that that is on the bridge to creating a good co-parenting relationship. My client acknowledges that Dale is a father figure to August, acknowledges that Dale and Ms. Holt are in a committed marital relationship, at least at this point. And although it would be ideal for both of these parties to communicate together because they did parent this child, we're not there yet. And again, to order our family wizard to require my client to essentially use a texting app, I don't think is appropriate. Again, my client is tired of answering or not answering at this point the same issues on repeat. So I would urge counsel to take a non-response as a response. So nevertheless, my client shouldn't be required to pay for attorney's fees for issues that he simply didn't agree with. And I don't think that that's an appropriate basis to request attorney's fees. As it relates to sole decision-making, the sole issue before the court from Ms. Holt's perspective is my client not taking the child to an evaluation that she scheduled, not consulting my client on a joint decision-making parenting plan that they have already. The other issue that she's brought before the court is him not attending appointments or asking that she take his schedule into consideration when scheduling the appointments. Again, these aren't major decisions that would require limiting decision-making. So we're asking the court to not make any changes on that. If the court is inclined to at least look into that, I ask that a guardian ad litem be appointed to investigate that. Again, Ms. Hegdahl has already shown has already shown an extensive history of attempting to alienate my client and prevent him from actually having a relationship with his child by ordering sole decision-making, which arguably she's already doing in violation of prior orders, would just give her that other step forward in that alienation attempt. So we're asking the court not to make any decisions on that. And I guess just as to fees, just because a party brings forth a motion doesn't make them entitled to fees. Again, my client has attempted to work with Dale in lieu of Ms. Holt in order to resolve a lot of these issues. Ms. Holt has simply refused to provide the information that he's requesting to make an informed decision regarding his child.
Ms. Jocelyn, rebuttal on those substantive issues, and then we'll talk about sanctions if you want to bring that up.
Okay. Do you want me just to reply, Your Honor, and then go right into sanctions?
No, substance issues first.
In regards to, and this is gonna go, I have to reply to this because that came in their response, but it should go to sanctions, where opposing counsel says, you know, he just wanted more information on the therapy center. That is just a complete falsehood. They got a very detailed email in January with 6 attachments clearly explaining why this child needed therapy. We provided that as an exhibit. They refused to respond. In February, I followed up. They refused to respond. So this argument that I just needed further information, he got it 8 months ago. Again, I don't know why they keep thinking we're not asking to change time. We're asking to have set days. You know, my client shouldn't be the only one who has to find childcare. Yes, he has family, but it's not up to her to do his childcare too when he makes 0 effort. And then opposing counsel stated, oh yeah, he gives enough notice. It's at least 5 days. No, it's less than 72 hours. Providing it less than 72 hours when you get it 5 to 14 days in advance is not forthwith. It's not right away. You get it 5 days in advance, you provide it that day. Regarding the 191, I'm not really sure what opposing counsel is talking about because I have a client. Opposing counsel was part of this domestic violence. We went month and months back and forth. We went to a lengthy hearing in front of a judicial officer who determined that he needed a domestic violence protection order against him, including the oldest child and my client. Regarding Dale, we can't force Dale to continue what we want to do. I really have no idea why this Our Family Wizard is such a big deal, except for this is his last stronghold to try and get her to do something. They've agreed to it multiple times. They agreed if we paid for it, but now all of a sudden they don't. This is the easiest way for the court to see who sent a message, when it was sent, when it was read, what the response is. And my client is hopeful that being held accountable by the court is going to calm him. Additionally, if the other side thinks my client's doing certain things or my client's also spilling rhetoric, it's going to keep her accountable as well. There's just simply no reason not to use it. And then the last thing is, to be honest, I'm super flabbergasted by opposing counsel's response. She doesn't now just get to come in after refusing to answer correspondence for 8 months and say, oh, no response is a response. That's not how you work with an opposing counsel. We have an active case that needs to move forward, that needs to end. You just don't say, nope, I'm not even going to respond. That is wholly unprofessional in what we do. You at least respond in some way, even if it's a no. And then finally, they haven't provided any documents to back up one thing that they've said today. My clients provided over 46 documents, healthcare providers, emails, declarations substantiating her point. And that's all I have on that reply or response.
Okay. So I want the parties to know, although I don't recall the CPO hearing, I did go back and look at that order and any of the exceptions to contact we put into place. So I have reviewed that since it was both parties discussed it. I have reviewed the filings of both parties for this particular motion, but what I would say in particular that where I think this case hinges, but for the agreement to change therapy providers, which you all, if you submit an agreed order, I will sign. What I think is really relevant is to go back to Judge Fassett's 2023 hearings. And the reason I do that is that a lot of these issues were discussed, either I'm reading them in Judge Fassett's clerk's minutes notes, particularly with regard to scheduling and days. There was extensive discussion about how the visitation schedule should be worded and very specific rulings on that. I also note that before the final orders were entered, and I understand maybe there was initially some agreement on some of these things, but Ms. Jocelyn, you had filed an objection on November 28, 2023, requesting a lot of the things you're requesting now, including Our Family Wizard. So these are not new requests. Almost every item, I don't see a specific request for the 191s, but I see that Judge Fassett, after hearing on the temporary orders, reserved on that. So I'm not going to revisit that. I don't find any reason. Absent a GAL investigation, which I do think is warranted, I don't find that there's any reason to revisit that. Similar with sole decision making, why would I, sitting here on a motion docket, go and change something that was already in front of Judge Fassett and specifically discussed at that hearing. In addition, our family wizard, Ms. Jocelyn, back in November, you were requesting the exact same thing and it did not go into the temporary order. The subsequent civil protection order also authorizes electronic communication between the parties. So I am not changing those things. I don't find any basis to go back and revisit things that Ms. Jocelyn, you have raised in the past and either abandoned for the temporary orders, or that Judge Fassett specifically ruled against. And when I say that, I mean, Judge Fassett was very clear about the visitation schedule coinciding with his work schedule. There are several sentences on her ultimate ruling on that. So no, I'm not going to modify the temporary order. But I am going to appoint a guardian ad litem in this case. Is there, Ms. Bliss had indicated agreement to that. Ms. Jocelyn, do you want to be heard on whether your client is agreeing or objecting to that?
I'm
sorry, I couldn't hear you.
She's agreeing, Your Honor. She brought that in her reply.
Let me, I'll ask about income here in just a minute, but let me get the first three names. Ann Height, Karen Lawrence, Amy Turnbull. So Ann Height it is, it sounds like.
That's
okay.
fine.
I'm going to appoint Ann Height. Let me ask about now. I have the temporary child support orders. I don't know if those are current.
I would just note, at least when those were entered, Miss Holt's income was imputed as she was underemployed. Hearing counsel's arguments today, it sounds like she does have a job and is going to school. So I think we may need to revisit that.
It's the same circumstance. She wasn't unemployed when child support orders were made. She was still working the same job. She just doesn't get very many hours. So the child support is the child support order is accurate. I don't mind reserving on the issue. For some reason, we find out she's making some tremendous amount of money and isn't forthcoming to the court.
And so her imputed wage was essentially minimum wage,
Yes.
32 hours a week, but I think she might be working a little bit less than that. Does that sound right?
Yes, she just works when she can. She gets some work based on the days off when she can do it. It's just so minimal based on the schedule.
Okay.
I'm fine with.
And I apologize. Sorry, and Ms. Bliss, your client is indicating, or at least child support order wages about $9,491 a month.
I don't recall if any major changes have been. I think it's probably consistent or just a minor cost of living increase, if anything. I would just propose that at least for now, we just adopt those percentages and then we can just reserve on reimbursement if it comes to light that they're making substantially different income.
Yeah, I mean, my thought is given wages though, I'm probably going to, at this point, apportion her contribution to county pay. So she won't be paying out of pocket for that private pay. Let's right now, give me just a second. Let's right now put him at 80% and 20%, but we can obviously visit those percentages, or if either party wants to bring that up. So her 20% will be at county pay, his 80% will be at private pay. I'll get that order. Do you all have, let's set a 30-day review that I can put into that order and a final review. I can get that order signed today. So we could do October 29th at 1 o'clock for a 30-day review. Will that work?
That should work.
Okay, and then where do you want final GA to be?
I think they're usually 120 days after the order is signed, so
I gotta count that.
4 months.
Yeah, 90 days after. So end of September or
January.
End of February is 4 months. Oh, sorry, end of January would be. I can't count today.
I know.
28.
We could. You want to do January 28 at 1 o'clock?
That's fine.
Okay. We'll do that. And then, so I'll prepare that order. You all send me an order changing the therapy. I think because of my ruling, obviously inherent in that is I'm denying the request for attorney fees. Ms. Jocelyn, did you want to be heard on anything else at this point?
Just one clarification and then sanctions.
Okay, sorry, go ahead. You cut out at the very beginning.
Oh, I'm so sorry, Your Honor. Just one clarification and then to be heard on the sanctions.
Okay, go ahead.
Just to clarify, I know it's not going to change Your Honor's order, but in regards to Our Family Wizard, I didn't abandon it. That was actually I think a motion that they had brought with the contempt. And then we did a clarification and then they just didn't follow through with the orders. It doesn't matter for today, but I think the clarifying is we're going to need to clarify how they communicate because the text message communication with them does not go well.
Ms. Bliss, do you have any other ideas for communication?
And from my understanding, Judge, and counsel can correct me if I'm wrong, but my understanding from discussions with my client is they don't text communicate anymore and they're solely using Dale, unless I'm mistaken.
And that's their only option is Our Family Wizard. If they're not going to use that, then they have to communicate with each other via text, which is just.
Counsel, I think you oh, here you are.
Can you hear me? Sorry, thank you, Ms. Bliss. I think I think it's my internet. Can you hear me?
No.
Okay. I think the issue is going to be without Our Family Wizard, text between her and him because Dale no longer wants to be that go-between. It does not go well for them. That's why we wanted Our Family Wizard. I can ask her if she's willing to pay. She doesn't want the text messages. And I think it's going to be just harder, but I don't know what else to do if we don't use Our Family Wizard, then these two are left to text one another.
Well, I mean, that was the contemplation in the CPOs that they would be texting about child visit safety and welfare. So I would like to keep it that way.
Which is okay. I'm just concerned with their communication style that it's not going to go well and it's going to go back to before, but maybe we can also have the GAL weigh in on that.
I think that would be appropriate. And I think that if the GAL is seeing that as a kind of a third party unbiased issue, certainly we can address that in our final orders.
Okay. That makes sense, Your Honor. I guess hopefully it'll go well. And then regarding sanctions, we had asked for sanctions in our reply based on CR 11 with them filing statements that they know to be false. Two examples are on page 4, lines 14 to 21 of his declaration. He states, now that I'm aware of this letter, meaning via this motion, all of this could have been avoided. Well, he was made aware of this letter in January and February, and this information 3 times in 2023. Opposing counsel and Jeremy both know that that statement is false. They weren't just given that information in September via this motion, but yet they wrote it. They also stated in their response that my client's failing to move this case forward, which they both know is false. We sent in a settlement offer, not for the purpose of saying what's in it, but to prove that we tried to move the case forward. We originally redacted it. When they said my client's been failing it, we sent it forward to show that we sent it in and again didn't get a response.
Ms. Bliss, go ahead.
As it relates to the letter, this coincides with what my client's position has been from the beginning. What was provided back in January, February, and the like was the reasons why Ms. Hagdahl believed that this child needed different therapy. Not any communication from a provider, not any communication from a doctor, and that is what he was seeking. Again, there's a lot of trust issues between these parties. My client just cannot take her word for things, and he is asking for some documentation to support it, not websites that she Googles or things like that. So that is the basis for our response, at least with regards to that, which I don't think is an appropriate sanction. Again, looking to the settlement proposal by counsel. Again, I fail to see how not responding or responding in part to a settlement negotiation is basis for CR 11 sanctions. Whether or not we're pushing the matter forward or somebody else is pushing the matter forward, either party can bring the matter for a settlement conference. Either party can bring a matter to go to trial. Failing to negotiate in a type of settlement when we have pending issues at that point with a CPO currently pending or just recently on the heels of one being entered is not appropriate. So we are asking the court to deny the CR 11 sanctions at this point.
Yeah, just to be clear, we didn't say that them not responding, that was brought forth because in their response, they say my client is not moving the case forward. That is not true, and opposing counsel knows that, opposing party knows that based on the letter. So had they not said you're not moving the case forward, you're trying to stall, or however it was phrased, we wouldn't have submitted that. We submitted it to show we are trying to move it forward. So what he had written is false.
Judge, I would ask you to consider the context in which that was written. It was in response to their allegations that we're stalling the process and making the matter not move forward.
I think
But they still wrote it. They still wrote we're not moving it forward. That's still a false statement.
Okay.
so. At this point, I'm denying the motion for sanctions. What I see in front of me is a very contentious family law case where I believe that there's not any outward attempt at deceit. I think that both parties see this case very differently. I think both parties see the actions of the other person very differently. I don't think that that is a sanctionable issue. I think it just adds to the contentiousness of this entire case. So I'll deny the request for sanctions at this time. I'm filling out the guardian ad litem order. And I just want to make sure. Is August still 2 years old?
Yes, he's about to turn 3, but I apologize. I don't remember that right off the top of my head.
I think he's about to turn 3 in November. If my math is serving me correctly. 2021 birthday, so yeah, 3, yes.
Then making sure. Making sure I get this order filled out. Hold tight with me in case I have any other questions for you all. Want to make sure I get in here. I'm including that the GAL is to look at all issues relating to the making of a parenting plan. Below, it's asking me for allegations. So are one or both parents alleging parenting ability or inability?
I guess in a roundabout way, right? My client is with her allegations. I'm not saying it's substantiated by this court of his refusal to participate.
Allegations of, so are both parents making allegations into parenting ability or inability? Or just petitioner?
My client obviously has concerns, so I think that it's fair to say from both, and a GAL can investigate. He's never made a claim that she's incapable of being the parent. I just think some of her practices are concerning to him.
Abandonment or neglect by petitioner and or respondent.
Nobody raised the issue of neglect.
Okay. Criminal history of petitioner or respondent.
No one's raised that.
Domestic violence of petitioner or respondent.
Yes, we raised that.
Okay. Mental health issues of petitioner or respondent.
My client has raised that in the past, so I think we might as well look into it.
Okay.
Then I would just look into it then for both, because that would probably be based on the other ones.
Okay. Physical health issues to be investigated of or respondent.
No.
I apologize. You said physical. Is it physical abuse?
Physical health.
Physical issue.
Oh, I apologize. I don't think either side's raised it. Have they, Ms. Bliss? Not that I recall.
No.
Any sexual abuse allegations against petitioner or respondent?
Though I don't know how you want to do that. That was raised in the DVPO, and she was granted a DVPO.
Well, because it's been alleged, we'll go ahead and indicate that.
Mm-hmm.
The allegations at this point, we'll look into substance abuse of petitioner or respondent.
I don't think either party has alleged any issues with substance abuse.
We alleged the substance abuse in our latest proposed parenting plan. If they want to, I apologize. We raised it in our latest parenting plan.
Oh, that's fine. You can look into it, or the GAO can look into it, obviously.
Okay. I'm going to just indicate any other issues discovered that could affect the safety of the children. We'll do a, what date? We set that for January 28th.
Yeah.
2025. Our 30-day review is
October 29.
October 29, 2024 at 1 o'clock. Do the parties want an interim?
I don't personally, but because I know the court typically likes those to come with motions if anybody's going to bring any sort of request. So I'll defer to counsel.
Yeah, I mean, if Anne gets us a temporary order, I agree with Ms. Bliss. Court wants us to note it up anyway for motion. So if we get one, either party can note it.
Okay, I'll just indicate NA as far as me.
Okay.
GAL fees, 80% paid within 2 weeks by respondent. Private pay, county pay is going to be 20% on behalf of the petitioner. Right in petitioners. And then we can also indicate if the party's financial circumstances change, the court may order the party to pay the fees according to their ability.
No objection.
Okay.
Can we also include, Your Honor, it said the GAL can weigh in on our family wizard. I think if it's not written there, I just don't want that to be a contention since it's been so competitive.
Let me put in other communication methods for parenting. I'll
And then,
put
oh, sorry.
methods. Oh, go ahead, Ms. Bliss.
Did you put a final report due date?
I put the final report to be filed and served on January 28, which is our final review date. Do you want that different than the final review date? I'm happy to change it. I have whiteout.
Typically we do the week before, but again, with the way that the bench has been going recently of no changes without a motion, I don't know if it really matters anymore to have it a week before. Counselor, are you fine with that date?
Yeah, I'm fine. I agree with Ms. Bliss on that. I don't think we need it earlier.
Let's just, we'll do January 21 for the due date.
That's fair.
Okay. All right. I've got that filled out and we'll get that filed. 6. Okay. Anything else on this case?
No, I'll get an order over to Ms. Bliss. I think we should be able to coordinate. It's really therapy and then deny. So okay. I don't think we should have any issue with that.
Okay. Sounds good. Thank you both. I appreciate you both being here and I appreciate your arguments.
Thank you, Your Honor.
Thank you. Rebecca Castle and Robert Polland. Okay.
In Your Honor, I'm here for Ms. Castle. I saw both parties on Zoom.
Yes, Your Honor, I'm here.
Okay. So I'm pulling up that file. I also just want to make sure I did get so the last thing I have in the file, and so I want to make sure I have everything you want me to have, is a September 17th declaration affidavit. It's 66 pages with attachments, but it's the reply declaration of Rebecca Castle. Is that the last thing I should have, or has anything been filed since the 17th?
Nothing's been filed since on that same day, Your Honor. There's also a notice of objection. I don't know if you got that.
I do. I have the 31-page objection to the proposed orders. Is there anything else, Mr. Polland, anything that you have filed?
No, nothing yet. I am working on getting some more documentation from my mental health, my clumpy illness, and while working on some videos that I'm compromising and putting together to send over to her as well.
Okay. I guess my question is how the parties want to proceed today. Are we moving forward on the temporary order argument, or I hear Mr. Polland saying he's wanting to get additional information to the court?
I'm pretty comfortable with moving forward today with what we already have and what has been submitted.
Okay.
Additional information.
Agreed.
Okay. Ready. And I did see both parties submit proposed parenting plans simply because petitioner submitted hers first. I'll go ahead and just start with Ms. Jocelyn and then I'll come to you, Mr. Polland, okay?
Yes, Your Honor.
Okay.
Thank you, Your Honor. And before we move forward, does Your Honor have a ruling on our objection to his proposed parenting plan and responsive declaration? The documents we were served were not signed. Also, the declaration he filed was different than what he served us, as there was a cover page. Additionally, his response is 18 pages, single-spaced type, which is in violation of the rules.
Yeah. I mean, there are some pretty big issues here, Mr. Polland, with what you have submitted. Are you aware of our local court rules?
No, ma'am. This was all the stuff that I typed up as soon as we had our previous first court hearing with you. And since then, this is kind of what I've had time to establish, type up, and or record.
Well, I mean, have you, Mr. Polland, at any point in time, have you had legal advice or representation in this case?
No, ma'am. I've actually had the process of moving and getting promoted within my job. So since this, I've actually been driving from Spokane on both my off days every Saturday to visit with my daughter, Riley. So I haven't had time or off time to actually meet with counsel at all since I'm living in Spokane now.
Well, I mean, part of my concern here is the parties are asking me to move forward on temporary orders where, Mr. Polland, to be perfectly frank, your declarations, your evidence is not in accordance with our local rules. So it's a big problem moving forward.
I'm fine with pushing it back, Your Honor. I guess the only question I have is, since we've had the first court hearing that you were the judge over, Becca did say on the record that she was not getting represented by any attorney, both in the protection order and the family court order. Now, with that being said, that's kind of what's interpreted in that what Ms. Jocelyn's objecting. So I guess I should postpone it, but I guess what should I do with this matter? Because Becca technically did lie under oath with her not having an attorney at all, and then coming back with an attorney, and then also having Ms. Jocelyn try to mitigate the process when you said it was supposed to be between Ms. Castle and I communicating over the times with Riley.
I'm not even following what you're saying. So you're talking about, hold on, Ms. Jocelyn, you're talking about a totally separate hearing, right? I have not presided over your temporary orders.
You did the protection order a couple months back, Your Honor.
Right, which is a totally different docket.
Right.
So for her to be unrepresented in a civil protection order and be represented here is perfectly legit.
I'm agreeing with you, Your Honor. What I'm saying is that I received an email prior to her even representing Becca under oath. This was dating back from, I believe, the first email I got from Ms. Jocelyn was dating March. I got to pull it up, and she also submitted it as well. So the first email I got from Ms. Jocelyn was March 22nd, which was before our court hearing.
Ms. Jocelyn, what do you want to say? I'm not even sure what the request is. I'm having a hard time.
I'm just trying to figure out because like I said, I'm fine with postponing to get more legal advice, because I know, like I said, Ms. Jocelyn reached out prior, especially with Becca saying that she did not have representation at all. And also Ms. Jocelyn got involved trying to mitigate our meetings on Saturday. And that was prior to against your court order.
So, Your Honor, we're ready to move forward. We want to move forward. I think I have no idea what he's asking. I think the problem lies, and I've tried to explain it to him, is there's two separate court actions. There's also different ways you can represent someone. He's also saying that I tried to mitigate. Mitigate's a good thing. We're ready to move forward. Honestly, Your Honor, if you consider the 18 pages, my client will withdraw her objection because she did a reply that was over limit to coincide with that. We're not entirely worried because the majority of his declaration talks about the DVPO. He's had plenty of time, so we're ready to move forward. He's just becoming more and more unhinged, and so there is a severe safety risk to the child.
Here's what I'm going to do. Mr. Polland, my initial ruling would be to strike your declaration in its entirety. When you file things in the future, either you need to get some legal advice before you do so, or you need to go online and look at our local court rules and make sure that you are in compliance with those. And I can point you specifically to the major court rule that most folks run afoul of when they're not represented is our local rule 88 that talks about the limits on length of what you can file. Okay. But if the other side has withdrawn their objection in order to proceed forward today, I will go ahead and consider your full declaration. Are you also withdrawing the objection to the unsigned pleading?
Yeah, if that's the only way that we can move forward today, Your Honor, we will withdraw it. I think it's probably the same thing that he filed. We just got unsigned copies. It doesn't look different. I
Okay.
just wanted to know. So it wouldn't change our reply or our response.
Okay, understood. So Mr. Polland, what I'm going to do, they've withdrawn their objection. So we'll go ahead and consider what you have filed. I'm going to go first to Jocelyn as the moving party initially on the temporary orders. Just like the last case, I'll hear from her first. Then I'll go to you. I'll hear from you. I'll go back to her for rebuttal, and then we'll make a decision on these orders. Go ahead, Ms. Jocelyn.
Thank you, Your Honor. As I said, in depth, so I'm going to be short and brief. I know Your Honor also presided over the DBPO, so you've had experience with these parties. My client filed a motion for a parenting plan. We're asking that her plan be adopted. She has been the primary caretaker since the child's birth. Mr. Polland has never taken on that role. My client had to return to work 4 months after she gave birth, and he couldn't handle taking care of the child. He couldn't handle her crying, and she wouldn't take a bottle, so he wasn't able to watch her. A few times he tried to watch her, he would show up to her work and drop her off and say, here, or he would just send her videos of the child screaming. Not why, just screaming. There were times my client had to bring her to work even because he couldn't handle her. He's never had an overnight with her. He makes little to no effort to see her. He never calls her to check on her. The only time that he calls is to talk to my client about her, the DBPO, contesting the DBPO, or returning his items. He never talks about the child and says, how's Riley doing? The parties originally, before Mr. Polland just continued to spin out of control, they had an agreement in December of last year that he would have day visits Saturday and Sunday. He only took her once or twice on a Sunday, and the visits ended early. Since January, he's only had Saturdays, and he often ends that time early. My client submitted a calendar of his visits. He's late 60% of the time to visits. And it wasn't until February of this year that he even had a visitation with their child outside of the house. My client's really scared for the child's safety and mental well-being while in his care. He continually puts no effort into consoling her. He gets triggered and angered easily, which can be demonstrated by the messages sent to her and the messages sent to me. He doesn't know how to care for her. He can't handle her. He can't handle a meltdown. And my clients even had to go and end the visit early because he was scared for her. She was scared for his safety. Additionally, when the child returns home from these visits, they're scheduled again for 8 hours. It's oftentimes not 8 hours. The child's so exhausted, she just falls asleep. He feeds her nothing but junk food and sugar. On April 20th, the child came home begging for my client to feed her because all he gave her was sugar. Additionally, he's not doing what's in her best interest. Mr. Polland up and moved to Spokane and has refused to give my client his address. He hasn't even acknowledged to the court in paperwork. He hasn't changed his address, nothing. That's why we're asking for the address. He hasn't told us where he lives. His time should be limited based on how he's treated my client and their child. My client, as Your Honor is well aware, was given a domestic violence protection order against him. The majority, I think, actually all of these instances took place in front of the child, and I just want to highlight just a couple really quick. On the 16th of this year of January, he assaulted her in front of the daughter. She had to lock her and the child in the bathroom to get away from him. He busted through the door. He pushed her over when he busted through the door. And when he finally got in and she was on the floor crying with their child, he was happy that happened. In New Year's Eve last year, he came over to the house uninvited, forced his way in, started screaming, cussing, calling her names, following her while the child's seeing this, and then he locked her out of the house and wouldn't let her back in until she said she's going to call somebody. He ripped the duffel bag out of her arms on that day as well. 11 days before that, again, screaming and yelling, he knocked the phone out of her hand, he body checked her, and she had injuries that day. 12/21 forced her to strip down naked in front of him and the child. On January 16th of 21, he kicked a laundry basket so hard, hitting her and the child. It was so hard that it left a hole in the wall. He also said, because my client wanted to leave, that if she wasn't home from work, or he got off of work, he was going to kill him. My client has further detailed her other 190 request factors in her declaration and her reasons for requesting an evaluation. Additionally, he is involving the child in the court action when the child comes back and says, when can daddy come back home? He continues to harass my client despite having a DVPO. He's only allowed to contact about the welfare, safety, and visits. On April 10th of this year, he called her. He threatens to reach out to law enforcement and say that her and I are breaking the order. Again, that's not allowed. He filed a complaint once even for me contacting him in relation to this parenting case, calling it harassment. He says he doesn't have time to talk. He swears. These are emails to me, Your Honor. He threatens every other email to file harassment charges. And one time he did, he sent me a detective's card. He says he's going to press charges. He says that to her. He says we're both breaching protocol. He says he doesn't have to talk to me. He cuts us in the emails. And additionally, in one of the texts to her, he was talking about somebody that he's dating, nothing to do with welfare or visitation. My clients also were asking for our family wizard. She's highly concerned that if we don't have this where the court can see what was sent, when it was read, when it was replied to, he's simply going to go back, especially in light of the fact that he believes he doesn't know who I am. He doesn't think he has to talk to me, and he doesn't acknowledge anything. This is going to deteriorate. It'll be easy for the court to see and hopefully keep him in line. Just really briefly on his declaration, is either spent responding to the petition for a parenting plan or ranting about why the DVO should be dismissed, which is highly concerning that he's fixating so much on dismissing the DVPO and not the well-being of the child. Again, ever since the DVPO, he has become more and more unhinged and his behavior is erratic. We quoted, she is concerned about his mental health stability, his drug use. If you look at, again, the emails, and I think I sent you like 20 plus emails from him, it further underscores his instability and his escalating volatility and refusal to take responsibility for his actions. He will just email me without giving me a chance to respond. He accuses me of lying. Like I said, every other email is harassment. He cusses at me in emails. He tells me he's going to send my emails to the clerk. Most of this I just bluff off because it's not relevant. But why I bring it to the court is to show him becoming more and more unhinged. He constantly tells me that he doesn't know who I am, that he's going to file harassment charges, that he's asked the clerk and they don't know who I am. Even when I entered an NOA, because he didn't understand the concept of the representation, he continued to make the same kind of allegations. And so, saying things like accusing Rebecca and I in one email of being shenanigans, and he can't keep his job because of that. I've asked him to remain calm numerous times, Your Honor, which he refuses to do. I've asked him not to call my office, and he called me 4 times on September 6th. What was also really odd is in the 5/17/2024 email that he sent, he wrote about himself in third person. I think as evidence today, he clearly doesn't understand that there are 2 separate cases, despite me trying to explain it, and he doesn't understand why or how attorneys communicate. When I addressed the issue about his DVPO violation, not saying you violated it, was here's what we're going to do about returning the lawnmower and trimmer. He accused me of not being her attorney and harassing him, saying, I don't know who you are. He's called me a liar multiple times, and my client has serious concerns, as well as, frankly, me, Your Honor, about his mental stability and the anger issues and how this is going to affect the child. I mean, he doesn't want what's in her best interest. He simply up and moved 500 miles away to Spokane and didn't bother to tell anybody what his address is. The first time we saw his address was when he filed his responsive materials in the bottom right-hand corner of the caption. We finally saw a Spokane address. Additionally, she has a vacation set from 10/13 to 10/18, which is based on him having a Saturday visit. So we would ask if for any reason the days changed or times changed, that she still get to go on that vacation. My clients cater the child's schedule, so he still has Saturdays to have the visitation. Her dance and preschool are on Mondays and Tuesdays, that way not interfering with, I might have quoted the preschool wrong, but dance is Monday and preschool a couple times during the week. And so she did it that way to not interfere with Saturdays. Him having any sort of contact with the child before a dance class or before preschool, it's not in her best interest based on what he's doing. And then finally, my client lost her Sunday shift work because of opposing party. And this came specifically from her boss. What would happen is there was 2 recent incidents where she was just fed so much junk. She was sick, and one time she had green diarrhea. My client has to call out and say, hey, I can't come in. That's happened enough times that her boss said, I can't rely on him, so I need to replace you for a Sunday shift to include somebody who I can guarantee will be here on time. So with that, we request our parenting plan, that he gives us his address within 24 hours and we order our family wizard.
Okay.
Thank you, Your Honor.
Thank you. And then Ms. Jocelyn, just briefly before I go to Mr. Polland.
Yes.
Given that now there is this Spokane residence, does that change, I guess, how does that change how, if the proposal is for daytime visits, I mean, what does that?
Can I talk about that, Your Honor? Because
Hold on.
I said, before I come to you, I just want to hear a little bit more about her proposal for how that's going to actually work in.
Yeah. So the thing is, he said he moved. My client had no documentation. He moved, no address, no nothing. We filed the motion with the agreement still for Saturdays. He moved and he still came down on Saturdays. And so we're requesting supervised time. So he can certainly come on a Saturday or a Sunday, or we can do it around a holiday schedule that has a certain amount of hours for supervised time. But he's the one who moved without telling anybody where he was and without an agreement or trying to discuss with her, like, hey, I'm going to move. Do you think that we could like look at a new plan? He moved. He has severe issues that need to be addressed. So he's going to need to come down here to have supervised visits with the child, whether he wants to come down twice a week and we find hours. I'm sure my client will be acceptable to that, but I don't see any other way than him driving back unless they do some like video visits or something.
Are you contemplating professionally supervised visitation, or is there a family or a friend that would be doing it?
If we can agree on a third party, we'll agree to it, not a problem. If not, then he would need to pay for a monitor, but we left that open. If there's somebody we can agree to, we don't want him to have to go against cost. So if there's a family member or a friend of hers or his that he proposes to me, we're happy to explore that.
Okay, thank you. All right, Mr. Polland, I'm going to come to you. Let me ask you some pointed questions, and then I'm going to let you tell me anything you want to tell me. First, I just want to clarify, they are proposing language in there that would specifically limit your parenting time and find that you have a domestic violence history. Are you objecting to that language?
Yes, Your Honor.
Okay. And then they are proposing language that would find emotional or physical problems, substance abuse, and abusive use of conflict. Are you objecting to that language?
Sober for 5 years, and I can prove that within the medical history that I submitted.
Okay. And then I just want to clarify, you have also asked for some limiting factors on Ms. Castle, alleging things like abusive use of conflict, withholding of the child. Tell me a little bit about that, and then we'll get into all the other issues like visitation.
Yes, ma'am, Your Honor. So I kind of will, as for limiting or saying my time prior to the original protection order that was placed, I wasn't allowed to see her at all during that time, or even the times that I was reached out. I worked graveyard shifts, so it would be 3 p.m. to about 3 a.m. at least, working for Pepsi when I was living in Vancouver. So I would only have Saturdays off, and Sundays I usually would get drafted to work because it was a union job. So this is the first time I was ever heard that I was able to see her on Sundays, and then once a protection order was placed, I only was allowed to see her on Saturdays. So I was not allowed to talk or do anything that wasn't involving or consistent about Riley. So the reason behind my move was I have identical twins on the way, and where I'm staying right now is actually a person that submitted a character reference and also has been a witness and has traveled down 3 out of I haven't missed a single day since I moved to Spokane. So I would usually drive down on my off day Friday because I work for Hertz as a supervisor, and I usually would meet up every morning at 7 a.m. and meet with Riley. So with my schedule changing because of the supervisor promotion, I can only go on my off days are now Mondays and Tuesdays. So that's partly why, but the reason why my address is not being disclosed was because the person that I'm actually having twins with, that I'm dating, they used to work together. So there is a they know each other, and that is a huge conflict right there, as well as I would get random texts saying that I hope that this wasn't your baby, because there was a period of time where there was a conflict that it could have been the person being with her ex, because they have a 2-year-old daughter that I'm pretty much the father of, and she loves me. And even Sadie has come down to visit Riley, and Sadie this morning has even asked about visiting Riley. So for my involvement with Riley and visiting and being proactive that is by far not the case. And so for me to say that, or for them to keep saying that I'm not showing up or I'm over late or I'm not there, that's not the case. Riley's tired because she gets to play with me. We end up going to water parks in Clackamas, Oregon. We go to a pool in the downtown Vancouver. We went to the splash pad and the Vancouver waterfront. We spend almost every day outside, whether it's swimming, whether it's playing, whether it's down at the park. We try to do all those. As for food and meals, for me, since I do travel down and I'm only there, I travel a total of about 12 hours to spend one day. I do have to supplement some food. So yes, I don't get to cook home cooked meals every day, but I still make it down and I still get to spend quality time with her. And I still try to do the best that I can with that. And I also bring Sam and Sadie. And there is some other things that I would also like to point out when it comes down to the stuff that I've submitted. Why it's been so frustrating with me and Ms. Jocelyn was before the original protection order was placed, Becca tried to serve me with one of her friends via email. So when I got a first email from Ms. Jocelyn, I was not prepared and I did question who she was because of some of the characters that Becca has surrounded Riley with, one being a registered pedophile in Long Beach. So with that being said, I did question and had very high questions and said some things like, I don't know who you are, God fucking name it, why are you not answering my questions? Because I then reached out to the clerk's office and that's what the pictures would be addressing. And it literally shows that there is no one representing her. Why is she trying to mediate this Saturday's meeting time with me and Rebecca? When me and Rebecca are just texting about Riley, to the point where times where I have literally said, please stop messaging me and stop asking me about this, because this would not go against the current protection order. And as for the cops, yes, I butt dialed twice. The cops did an investigation. One was by Mr. Weldon in Vancouver, and one was done in Longview the day that the order was set. So I actually did change her name in my phone so that wouldn't happen, because obviously prior we were dating, we raised a kid together, so it was set to wife. Obviously with the name, I changed it to Riley's mom, so I wouldn't have that happen again. So all of this is very, very relevant into what's going on. And the pictures that I submitted, and then obviously the message I've already submitted Samantha, which is my current girlfriend. She's the one that's been down there every weekend with me, as well as Becca did mention a lot of stuff about my family. My dad's flying in October 6th or October 5th through the 7th. That would be a Monday and Tuesday. Our goal and hope was to go down and visit Riley, because we've been Skyping Riley every Saturday. So he is also a witness into visiting what is going on and what has happened. So I even traveled down one day on a Monday. I don't know the exact day. I would have to look it up, because Becca asked for my help to watch Riley because she had a OBGYN appointment. I drove all the way from Spokane to Vancouver to watch her, and she flaked out that morning. After
Your Honor, we're going to object. This was like 4 years ago, not after he just moved to Spokane.
I understand. I will give it the appropriate weight, but Mr. Polland, let's kind of narrow in a little bit and let's talk about kind of current day.
That was current. How was that? Riley's only 4. That means she would have happened that prior to her birth. So 4 years ago, Riley wouldn't have been born. And if I'm referring to this being in Vancouver, like I said, how would that be 4 years ago? Okay. Okay.
I've overruled. I'll give it the appropriate weight. So let's go.
So the relevant concerns that I want to bring up, where there's over.
Hold on. You talk over me. What I am saying is you don't need to rehash or read everything you have filed. I've read your declaration. I'm considering it because the other side has withdrawn their objection. So I don't need you to reread that or rehash that. Oral argument is a time for you to pinpoint those things that you think are most relevant for me to consider.
I mean, the only thing that I would want to pinpoint is this is the second time going through this with the same stuff that she is consistently lying. I have been telling the same story, whether it's been the protective order or this. I would, my only thing is, I know what it's like to lose a kid. She brought that up during the protective order. As everybody knows, because I said on the record, I did sign my rights over to my son when about 7.5 years ago, because I wasn't the right person. I wasn't a good father. I have done everything right this time. And That's the one thing I can say. Everything has been consistent with my end. The stories, everything. That's
What are you? Okay. Are you objecting to using our family wizard to communicate about child safety and welfare?
I'm completely okay with that. I've even said that in the declaration.
Okay. And then with regard to you now residing in Spokane, how are you seeing? I know I read your proposal, and your proposal is essentially to have 72 hours with your kid all at one time, but you are suggesting that it would be up to mom to bring kid to you and then take her home.
My theory is I'm willing to do the driving. I've done it this far and this long already, and it is a brutal drive. It is a very long and awesome. And when it comes around, it is not going to be an easy drive. So I'm fine with doing that, especially at first. If I get denied, she has a family up here that is going to be her second home, her second family. She has stepsisters up here that are going to be born in January. So I would like her to be a part of that life. She has a second grandmother waiting. We have a huge farm. We have a cookout every week. We're very homestead family oriented over here. So having that just quality bonding would be a lot better than having the one day going out and trying to find something to do, because the current time from 7 to 3, with her getting older and growing, she sleeps a lot more. So we usually have quiet time between 10:30 11. And no, she doesn't always sleep, but I can get her watching TV or lay down for a little bit. But then by the time, everything starts opening up on the weekend, she has to go back home to her mom. So there's not much to do besides eat breakfast and have lunch, because by the time everything opens is 10:30 11. She has to go back by 3. And quiet time, because I got yelled at multiple times from Rebecca and her Miss Shawson about quiet time and nap time. So I try to always incorporate that, especially when Sam's there too, because she has a 2-year-old. We have kids around us 24/7 that we are trying to raise to be good citizens, not just kids trying to be good adults.
Okay. And then how often do you come back to the Cowlitz County area, if at all, or are you not planning to?
I only come back to visit her. I don't plan on coming back to see anything else. There's nothing there that way. Me working, I am off Monday and Tuesday. So with me working, I don't really have time. I do all the oil changes at night and all the tire rotations for Hertz as a supervisor. So.
Okay. Anything else you want me to know?
Just hopefully we find an answer, because this is definitely on a health standpoint not fun for either one of us and for Riley. I know that for a fact.
All right, Ms. Jocelyn, rebuttal.
Brief, Your Honor. One of the things he states in his original proposed parenting plan when we filed this action is that he wanted Saturdays for less than what they are doing now. That's his position. Then all of a sudden, when we file this motion, he now wants 3 days in a row in Spokane and having a small toddler drive back and forth. That is not in her best interest to go from day visits, never having an overnight, to 3 nights in a row. He's clearly not thinking in her best interest. His information, I know the court gives it weight, about the emails he brought up. They were after I filed my NOA. His emails that he sends to me, he states they're met with pleas. No, they're met with harassment. So much so that I've thought about at what point do I need to file an anti-harassment order against him. Regarding the phone call, again, a falsehood. He originally said to my client that it was a butt dial, but now before you, Your Honor, he's saying he called somebody else instead. He doesn't allow the child to nap. He's again made false statements to the court saying that I yell at him. I've never spoken to him, so I have no ability to yell at him. He's never disputed in his declaration, at least that I could make sense of. He didn't say he wasn't who Sam and Sadie are. He doesn't have her for 12 hours. The schedule that they had in place for Saturday and Sunday was an agreement made by them. And then when he couldn't make Sundays, they agreed to Saturdays. He didn't ask for any other day. My client has no issues with his dad coming into town and him coming to see Riley. She's happy to arrange that with his dad. Regarding our family wizards, again, a falsehood. He states that he agrees with it. However, after I filed the motion, I asked him if he had agreed to it. He said no. Putting this child on a 500-mile drive each way is not in her best interest. Additionally, he's about to have twins. I don't think that he realizes how much that's going to entail and the efforts he's going to have to put in. And again, there was no reason he had to move. It's not like he got fired and had to move there. It's not like he was losing his place. He actually still has his place down in Vancouver. He chose to move. So the child shouldn't have to suffer because of something that he voluntarily chose to do. And that's it, Your Honor.
Okay. Let me ask, is either party, yeah, Mr. Polland, go ahead.
I do want to point something out that she made very kind of relevant. She's right. I didn't have to move, but let's think about everything that's said or done and some of the health factors that I pointed out, whether it's the first one or this one. The fact that, like I've said, only seeing your kid once a week is not a father. I can still be a father and drive and spend my time and still be a good supportive dad from a distance. And I do that by making the time every weekend. And every time that Becca needed help, I made it down there. So for me to hear that, it's hurtful. I know that doesn't really make a difference, but it's one of those things that you're right. I didn't have to move, but we also could have talked and communicated throughout everything the right way, but that also didn't happen. So I got to do what's best and what's out in front of me right now.
Is either party requesting a GAL?
No.
I don't know what that is, so I could not.
It's a guardian ad litem who.
No, there's not anyone we could agree about. I know that.
No, that's not the question. It's a professional who meets with both parties and makes a recommendation to the court.
Neither party has requested that, either in pleadings or in emails.
We're fine without that.
You're fine without it? I don't know if I am.
I mean,
I think there's a lot of allegations both ways.
I've brought, ever since the first thing, all I brought up was her mental health and getting the right help. And then once this happened around like this, I did amend my parenting plan to modify it for after this, and obviously the allegations and some of the lies. But I don't want to make it worse than it already is. You know, like Riley's struggling. Obviously, I mean, Becca is trying to put up a phase that she's scared, but yeah, she'll tell me that she's redoing the house. She'll tell me, you know, she'll straight up blatantly text me about the twins and Sam. So it's, I mean, I would love an investigation, but you know, it's just going to hurt more people than it's going to help. And that's not the goal.
So first of all, I am going to give you my ruling on a parenting plan today, but I am going to, at the court's request, ask for our, I think we're going to appoint a GAL. I'll talk to the parties about how that's going to get paid for here in just a minute. Sorry, I guess he's not going to do this. No. So let me pause this case just for a minute. Mr. Anagnosto, are you able to hear me?
Yes, Your Honor.
Okay, I just wanted to let you know on your case, I just heard back from Judge Basher and he is not stepping on. So we do have to set this over. So I'm going to give you two options because I don't want to keep you in any longer than I have to.
I appreciate that.
He is back on the docket October 15th. Or if we set it to the 1st or the 8th, it's going to be someone else. It's up to you.
And he doesn't have a presentation docket on Fridays?
No, well, he does, but he'll be gone. So
got it. Oh, well, then I would prefer that it be on the 15th in front of him.
Yeah. Yeah, sorry about that. So we'll get your case set over to October 15th. That is the remind me the number 213004580, the Smiley matter.
Right, Smiley.
Apologies to the clerk for midstream going into a different case. Okay. Okay, great. Okay, Mr. Agnosto, we'll have you back at that time, okay?
So October 15th at 1 p.m.?
Yep.
Got it.
Did I say that date right? Yep, the Tuesday. Yep, that is correct.
Thank you.
Okay, thank you. Okay, yep. Okay. So I'm going to talk to the parties here in a minute about their income with regard to the GAL, but we're going to circle back to that. I'm going to go through my ruling here in a minute. I'm going to be making some changes to the petitioner's proposed, but in essence, I'm working off of your proposed parenting plan filed 8/28/2024. So this will be a temporary order at this time. And Mr. Polland, what that means is it's going to temporarily dictate what parenting looks like. A GAL is going to get involved, meet with both parties, make recommendations to the court before any party moves for final orders. Okay, so anything I'm ordering right now can be changed. Okay, so based on what I have in front of me right now, I am going to put the 3A limiting factor on Mr. Polland with a finding of domestic violence. The 3B factors with regard to abusive use of conflict, substance abuse, emotional or physical problems on both parties, because there's allegations on both sides, I'm going to reserve pending evaluation and input from GAL or other professionals, frankly. So I'm not going to make any specific findings right now. All of that will be reserved. The 4A evaluations or treatment required. For Mr. Polland, I'm going to require anger management and domestic violence. I will, because there's an allegation at this point, I'm going to hold off on requiring the substance abuse evaluation. For me, it looks like that history is pretty long ago. So I'm going to hold off on that unless the GAL requests it. We can revisit. For Ms. Castle, I'm going to require a mental health evaluation. Decision-making is going to remain with Ms. Castle at this time. Number 6, dispute resolution. Parents will go to court without having to go to mediation, arbitration, or counseling. I think that those other methods probably won't be reasonable. Ms. Castle will remain the custodian for purposes of designation. With regard to visitation, obviously primary is going to remain with Ms. Castle. There will be at this point visitation with Mr. Polland. I'm not going to require that it be supervised, but it will need to take place during those normal hours, the 7 to, let's say 7 to 4, Saturdays and Sundays. So not overnights at this time. And again, that's pending additional recommendation to the court after our GAL investigates this case. So not supervised, but no overnights at this time. And the visits do need to happen in Cowlitz County. Now, I am going to also authorize video visitation to occur between Mr. Polland and the child, noting that I doubt every weekend he's going to be able to get here, nor would I expect that probably to occur. So Mr. Polland, we can specify that it's every other weekend, which is pretty typical, or if that's burdensome, we can do every third weekend and then video visits in between. Again, what will work for you on a temporary basis?
I'm fine with asking through the wizard a couple days in advance, whenever or however it's set. The only thing I do want to point out is I do work Sundays, so I'm off Mondays and Tuesdays. Sundays is our most busiest days on car return. We average about 300 cars a day on that day.
So are you wanting visitation? Would you be here in Cowlitz County Mondays and Tuesdays?
I'm finally driving up Sunday night and being there. I usually, if I were to do that, I would probably be there by 4 in the morning, so I can still make it by 7. I'm fine with doing that. Any day I can see my daughter, I will gladly do that.
Ms. Johnson.
We would have severe concerns if he's working all day, driving all night, getting here at 4 a.m. Additionally, the child has dance that day, and then preschool on Tuesday, she's out at 12:30. If he wants to come down on Tuesday after preschool for a visit, that's no issue. But him coming down on 3 hours is not in her best interest.
And so are you always going to be driving, or are you ever going to catch a quick flight over? I mean, that's
once we catch up on some bills, since my girlfriend just got laid off with twins on the way and a daughter, since her and her ex co-parent extremely well, they're not going to go through the court or anything like that. We're actually good friends, so right now, once we get caught up, the tickets are about $200 round trip, so I could fly into Portland and then use the discount from my company. So until we caught up, I gotta pay for mortgage here.
So again, let's say it's Mondays and Tuesdays. How often do you think you'd be doing that? Let's say every other week, or?
I haven't missed a Saturday. I always plan financially usually it takes about $240 to get down with gas.
Okay. So we'll do Mondays and Tuesdays, 7 to 4.
Your Honor, she's in school and dance, so she can't do it on those times. My client planned those times because he had Saturdays. So, and also he's not using Sundays, he's just using Saturdays.
Okay, so she's 4, so she's not in mandatory school. What does schooling look like
Your
for
Honor, I can explain that a little bit better. So she just recently started the Smart Start early preschool start over at the Exodus Church. I pay about $300 a month for tuition, and she just goes Tuesdays and Thursdays from about 8:30 to 12. And it's a school program. They go off of a learning basis instead of like daycare. It's not a daycare, it is a school for her age.
So, okay, thinking about this, so Tuesdays don't work. And I do understand, I think getting her into that Smart Start for preschool makes sense. I don't want to interfere with that. So Mr. Polland, I'm trying to give you some residential time here, some visitation time. Do Saturdays still work for you?
Not at the current moment. I have to talk to my bosses and possibly figure that out. I know originally it was Friday, Saturdays, and then with the promotion, I was the only one that got it. So I don't know if that would go back to being changed like that.
Okay. So it sounds like the only day that works is Monday.
I'm willing to even take 2 hours. I mean, like I said, it's not terrible, but it's worth it.
But he's going to have 3 hours of sleep, Your Honor, and have driven 500 miles. And based on his actions, the child has dance. It's going to complete.
Hold on, Ms. Jocelyn, sometimes I get 3 hours of sleep and still parent, okay? That's not what I'm basing this decision on. Ms. Castle, what does this child's Monday schedule look like?
On Mondays, we have dance out in Chehalis. So we leave the house about 1 o'clock, and it gives us time to get ready for dance that starts at 3, drive out there from Longview. And dance is about an hour long, and then we usually go out to dinner at a restaurant, and then we head home because she'll fall asleep in the car after dance and she's ready for bed. We usually get home around 5 or 6. And there was a Saturday dance class. It's all full now, both classes are filled, but I didn't do the Saturday dance class due to him having the Saturday work schedule. He's just recently started this job just a couple months ago, and his job history isn't the best. So in all honesty, he'll probably have Saturdays with a new job here soon.
I just want to point out, Your Honor, but that exact reason is why I would want to move, and why I did move, is that negativity constantly. And while you live with that for 3.5 years, it's not a good image to keep around your kid.
Well, I mean, look, here's the deal. I'm not calling this negativity, Mr. Polland. This is a mom who has enrolled your kid, in a Smart Start preschool program. I'm not going to interfere with that. What has changed is your schedule, and I'm not faulting you for that. You have to work. You have to create a good life for yourself and your family. There is no fault, but to me, the only thing that actually works for both parties is every Saturday, because it sounds like that might still work for you. So for now, in a temporary order, until everyone has work schedules defined and we have a GAL investigation, we're going to do Saturdays from 7 to 4 for visitation. I will, if you end up staying in town, I know you probably won't because of your Sunday work, but I will also add Monday morning visitation for you. If you can't do that, then on Monday, that will be video visitation time. So Ms. Castle will need to make available in some way the child for video visits with Mr. Polland on Monday.
It's not a problem if we can just get notice so she knows to have the video visit ready.
Okay. That can be done through our family wizard, since you guys will be using that to communicate. Again, this is not supervised time on Saturday. The holiday schedule, that is being proposed, essentially, Ms. Jocelyn, are there changes being requested at this time? Your August 28th proposal has him during the day for Father's Day, even years, Thanksgiving Day.
Yeah, we just kept it the same, Your Honor, the 7 to 3:30. And then what I tried to do was alternate the majors. So I think if we could go with that, and then pending like the GAL. It just makes sense, just keep the same schedule, 7 to 3:30, or we could put 4, that's not a problem.
Yeah, let's do 7 to 4 on all the times. And then I'll adopt your holiday schedule. I understand that's not always going to work with his job. And we are, before we get to final orders, going to have to figure out what holidays look like. But before I'm allowing visitation in Spokane, where kiddo goes to Spokane, I want those evaluations to take place first. Okay.
I do have one question.
Go ahead.
So I'm going to be reaching out to my boss right now to see if I can at least change off Saturdays and maybe work Monday or Tuesday. My only other question is with this new order in place and with me doing the evaluation for domestic violence or class, whatever, am I allowed to get my gun reinstated after that? How does that work? Because I had my concealed permit before that. Like, I've never had domestic violence charge in my entire life.
Sorry, are you allowed to get your gun rights back? Is that what you're asking me?
Yeah, because the only charge I ever have is a reckless driving.
So I can't give you legal advice on your gun rights. I would recommend you talk to an attorney about that issue. And in the family law case, we're not addressing your gun rights at all. So that would just be as a result of the civil protection order. So talk to an attorney about that or reach out to legal aid.
And is that protection order still in state as of today with this court hearing? I guess is the best way to put it.
Yeah, the civil protection order dockets stand alone from this case. So nothing I'm doing here today negates the protection order.
Okay, I thought because I was going to be in review with this case eventually. That's what I thought was under.
Someone would have to move to have the protection order modified or reviewed, and you can do that. You can file a request for a modification. Okay. I'm adopting. We'll have to make a change to number 12, transportation arrangements. Obviously, right now, temporarily, while they're residing in separate cities, the Mr. Polland is taking the obligation to drive to Cowlitz County.
Your Honor,
can we keep it? Oh, hold on, Becky. Can we keep it at Woodland because that's what they have been doing is the police station pending the DBPO. Like they've been meeting for his visits. She doesn't want him coming to the house.
Okay, yeah, we can keep Woodland Police Station as the exchange location when he does come to town. The standard language as far as relocation will stay in. Ms. Jocelyn had proposed some miscellaneous, very standard language regarding attending activities and child involvement and homework and all of that stuff. That's all really standard language that I will adopt. The only question I have that most people have some feelings on one way or the other, Mr. Polland, I'll hear from you. Ms. Jocelyn is recommending language that the child would not be introduced to romantic partners until each parent has been dating someone for 6 months. And then one parent has to give the other parent the first and last name of the person they're going to introduce. I don't know if that is already a bridge that we've crossed.
That bridge was already crossed, and that's probably why this is happening and to the extreme that it is.
Okay. Ms. Jocelyn, I guess how strongly you're advocating for this language, I'll hear from you.
I mean, I think it's important, but the problem is he's already done it. I think what we do need in lieu of that is the person's first and last name. And we still need to know his address. He's still not provided. So if we can get him to have him email me that within 24 hours, I can strike 15 out of that.
Your Honor.
Yeah, it's okay. I'm striking 15. I'm not including it. I think that
I've had 3 home invasions. I don't want, there's a reason why I didn't want to get Beckham address.
The GAL is going to get that information. The GAL will have to know who is in your home for background checks. The GAL will have that. I don't need it in the order. And I understand that sometimes these types of provisions are a way for one person to kind of keep tabs on another person. So I'm not going to go down that road in this situation. That bell's already been rung. So 15 will strike. The only other thing I wanted to do, is there any clarification the parties need on the parenting plan, the temporary parenting plan? Otherwise, I was going to move on to getting a GAL formally assigned.
I think the only clarification, Your Honor, is if we can have a set time that he has to notify if he's going to utilize that Monday video visit and a set time for him to state if he's coming down. Because if he's not coming down, we don't want the child getting ready to go. So if we can just have a video visit and I think confirmation 24 hours in advance, since we're already used to the Saturday, I don't think we need it more than that.
Mr. Polland, do you have a time kind of I would say at least 3 or 4 days ahead of time where you would know, hey, I'm coming down Saturday, I'm doing video visits Monday. When would you normally know that?
Oh no, I haven't missed a Saturday and I don't plan on it unless it's inclement weather. That's how it's always be. I will always be there Saturday, and Miss Jocelyn will know. If I won't, I'll email her 72 hours before, like I did this past weekend. As for video chats, I'm fine with either around right before a nap, either right when she gets up, or but whatever floats her boat. And the only reason I'm saying that is I know Monday's dance, and then I know they go to Becca's boyfriend's house because me and Riley have talked about it. So that's just like I said, it's the line has been crossed a lot. So I'm fine with whatever works for them. It's the point of just making it work for our daughter.
So it sounds like he's in agreement with 72 hours, and I'll just get a time from my client and then I'll give it to him. If it doesn't work, we can talk about it at entry.
Okay, that works. Let me get a list of the next 3 guardian ad items and I'll read those off, and then Mr. Polland, I doubt you will know anyone, but if you have an objection to any of them, I'll hear about it.
Karen Lawrence, Amy Turnbull, or Sherry?
Karen Lawrence, Amy Turnbull, Sherry Evald.
I'm fine with whatever works.
We'd strike Sherry. Amy or Karen is fine.
Okay, the first one was Karen Lawrence, correct? Okay, I will, Karen Lawrence will be assigned. I have listed on here the various allegations that have been made and the issues I've reserved on, which include parenting abilities, abandonment, or neglect. Again, these are allegations that she'll look into. I'm not making any findings of this. Domestic violence of respondent, any mental health issues of petitioner or respondent, substance abuse allegations of respondent, any other issues discovered that could affect the safety of the children. And I am going to put in here input on visitation out of county with respondent. I can go ahead and use the last dates we used in the prior case. So that would put January 21 as the due date for Ms. Lawrence's report. Our first 30-day review when we come back to determine, just make sure parties are touching base with Ms. Lawrence, that payment has been made. That'll be October 29 at 1 o'clock. And then the final GAL review for now, we will set to January 28, 2025 at 1 o'clock. Current income of these parties, what does that look like? First for you, Ms. Jocelyn, for your client.
We haven't done anything with finances. We have no child support order, so I don't have that. I'm wondering if the easiest thing to do is to exchange pay stubs, like a current year-to-date pay stub. And if we can't agree like on a proportional, just argue it at entry, but have maybe each side within a week provide the last 2 pay stubs.
Mr. Polland, do you know what your general income is right now?
I make 21 an hour for the next 90 days and goes up to 22, Your Honor. And I will say I do have a verbal word from Rebecca, as well as it's on a video stating that she will not ask for any child support or any help.
I'm not talking this isn't for child support. This is for payment of the GAL fees. So you get $21 an hour full time.
Yes, ma'am.
Okay. Ms. Castle, just for purposes of me determining who pays for the GAL, what do you approximately make per month?
So I'm actually working 2 part-time jobs. The first one is a 1099 job for mobile dog grooming, and it's part-time. I'm only working about 6 hours on Friday and about 6 hours on Saturday, and I make $25 an hour. And then my other job is for a security company, and I am part-time. I make $22.50, I believe, and I work 3 8-hour shifts a week.
So how many are you working? How many hours per week are you working between those 2?
About 36, maybe 40.
Okay, so full-time-ish. Okay. So what
But the one is 1099, so no taxes are reduced out of it or anything. I have to pay those at the end of the year.
You make a little bit more per hour than he does, but I think probably because of that issue, it balances out a bit for purposes just right now. And I'm going to include language in here that we can review for reimbursement to the other party at another hearing. But for now, we're going to split the GAL cost 50-50. And I'm going to indicate we'll reserve on reimbursement to the other party pending a formal hearing if any party wants to note that on with pay stubs.
That works, Your Honor.
Okay. Okay, that is all I have on that order. Anything else the parties need from me? And we could set this on for presentation. I think that's probably going to be necessary. So, Mr. Polland, what I'm going to do, I will be back on this docket in Judge Basher's absence on the 1st and the 8th, I think. I know for sure the 1st. So we could set it on for next week if you think you could get that temporary order modified, emailed over to Mr. Polland and filed with the court by next Tuesday.
Hold on, let me double check, Your Honor. And would it be afternoon docket next Tuesday?
Yeah, it'd be 1 o'clock next Tuesday.
The only way I could do next Tuesday is if we did it at 3 o'clock or after, as I have a conflict until 2:30 and just give it some time.
Do you want to, we could do it on the 8th. I don't know how long that docket will go next week. I'm just looking to see. I don't know how long. Let's see.
The 8th, I have a pretrial in Seattle, so I just need to juggle between the two. I can't imagine that pretrial is, so I just have to skip. I mean, the other option is, I know it's not ideal, but I don't know if you're here on the 29th and we're here for the 30-day.
Yeah, I think the parties probably want to get it entered before then. Why don't we let's put you on the 8th at 1 o'clock and then just message me. Mr. Polland, will that work?
Yeah, Tuesday I'm off for sure right now. I'm talking with the boss.
Tuesday the 8th at 1 o'clock for presentation of the order. And if Ms. Jocelyn, you're having, other court appearance issues, just send me a message, whether you want to be called first or you want to be later in the docket. And we can do that.
No problem. Hopefully we don't even have it and it goes away, but I'll just email Your Honor and let the other side know.
Okay. Okay, great. Anything else today?
No. Are we just reserving on the issue of the address then?
Yeah, I'm going to wait and have the GAL, but there are some concerns. So I'm not going to push that issue in the specific order at this time.
That makes sense. So she's not going over there.
Sending kiddo over there right now.
Yeah.
So.
That makes sense. Thank you, Your Honor. I will send this over to Mr. Polland and see you on the 8th.
Okay. Mr. Polland, anything else for you?
Nope, that's it. Thank you, Your Honor.
All right. Thank you both.
Thank you.